Welcome once again to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, you're in a better position to understand how to protect yourself, your family, and even your business. We continue to provide information and resources that'll help you to determine whether or not you need or want to contact a lawyer. Perhaps will help you to determine that you can handle some issues yourself. If you do decide to seek outside professional counsel, you'll be better prepared, and of course so will the professional you select. Our goal, of course, is to help you save time, money, and achieve the best possible results. The Bazar and Associates law firm in East Providence continue to help us with each topic that we tackle. Welcome, David Bazar. We often talk about a wide range of topics, and always David addresses them as the lawyer. Today our topic is alternative dispute resolution, basically mediation and arbitration, and he's also a mediator. So at some point we'll be crossing over and making sure that you have that distinction, and there is a distinction. So just about everyone, perhaps with the exception of some lawyers, agrees that litigation is generally something you want to avoid. It's time-consuming, it's aggravating, it's emotionally draining, it's unpredictable, you don't always know what the results will be. And sometimes it's fairly inefficient. So many are considering that there might be a possibility of taking another route, namely mediation and in some cases arbitration. Might it work for you? Who knows? We're going to go through that today. So there's a difference between mediation and arbitration. There are similarities. David, give us a little tutorial on it.
The similarities are that they're both forms of alternative dispute resolution, but how they work is actually very different. Mediation involves an independent or neutral mediator who tries to bring both sides together but does not have any authority to require either side really to do anything. So if an agreement is reached, and I find it particularly useful in the family court setting, for instance, because a decision that's made by the two parties to mediation is their agreement, it's their decision, as opposed to a judge or some other party imposing an order or agreement upon them. So usually those agreements work better because the parties have reached it themselves. So the mediator's job is to get the two sides to come to an agreement, whereas an arbitrator listens to evidence presented by each side and then writes a decision that can either be a binding arbitration decision or not.
So both of these, as alternatives, are considered to be making reasonable solutions, having acceptable outcomes. I don't know if there's ever really a win-win, but everybody wants to talk about a win-win and how positive that is. And I guess it's become popular. You mentioned on family court divorce cases. It's civil, it's with business. I guess it's with real estate, other kinds of disputes. But does it always have to assume that the two parties are willing to communicate more effectively together rather than just have the gavel come down on them or a jury or whatever?
Right. So the two different types of alternative dispute resolutions can be very successful in a wide variety of different types of cases. But what you were just talking about in terms of communication, that's where I was really leaning for mediation in family court, because a lot of times people are in family court because of their inability to communicate. And one of the processes that you go through in mediation is to communicate with each other, and hopefully at the end of that process, your ability to communicate with each other will improve, because one of the things we try to get the folks to do when they sit down for mediation is to, number one, present their case in a very dispassionate, unemotional way, if you can, but more importantly, to listen. And to be an attentive listener, meaning that you're not just sitting there hearing what they're saying, but you're listening to what the other person is saying.
So if, let's take that example that you have with the family court. If you have a mediator, is there a mediator, one for each side? And with arbitration, you have one for each side and a third. How does that differ?
So they are different, and with mediation, usually it's just one mediator, and that mediator is a neutral mediator. In other words, the mediator isn't there to advocate for either side. The mediator is there to try to bring the two sides together. And there's a lot of different ways you can enter into mediation. In sticking with the family court in Rhode Island, there is a mediation unit in family court that the judges can assign the parties to go to mediation. And in some instances, they're required to send the parties to mediation before you go to a hearing or any further litigation in front of the judge. You can also do mediation privately. So again, mediation, usually one mediator, and both sides may or may not have lawyers there to present their case or to discuss the case. In family court, I find it more effective if lawyers are less involved. Sometimes they're helpful, but usually, again, for the communication purposes, it's better for the parties to be able to speak, especially where children are involved. Arbitration, different. And there are different types of arbitrations. Again, in Rhode Island, Superior Court has a program where there's court-annexed arbitration, which is a process that you're required in many instances to go through before you get to litigation. And the arbitration list of arbitrators, on that list is a required list to pick from as to who your arbitrator may be, and it's one arbitrator. There are other forms of arbitration under many insurance policies, uninsured motorists, for example, that requires arbitration. And oftentimes it might require what we call a three-panel arbitration. And that's one where each side picks an arbitrator, and then the two arbitrators pick a neutral arbitrator, and then the three arbitrators hear the case, and they reach a decision together.
So whether you went through litigation or the ADR, alternative dispute resolution, still cases have to be prepared to some extent. If someone is coming to you, say they're going to plan on having a divorce, how would you approach, well, would they say to you first, gee, David, I'd like to have you be a mediator, or gee, David, represent me as my attorney? Would you be ever in a situation where you would try to steer that one way or another? Obviously, lawyers make more money than mediators from what we hear, although maybe not.
Well, I will certainly say, and you're using the family court again, in the family court setting, if you can mediate and resolve a case short of litigation, even though you then still have to hire an attorney to bring to the court whatever agreement you've made, you will almost always save money because it's cheaper to pay for a mediator and then one or two attorneys to put a case through on an agreed-upon basis than it is for each party to hire an attorney to go to court to fight and litigate over an issue that can be resolved. So if someone comes to me with an issue and they are coming to me not as a lawyer, but to find out about mediation, I'll explain to them, first of all, I want to meet with both parties, and I'll explain to both parties, I'm not an attorney in this instance, I'm a mediator. I don't represent either one of you. And I explain to them the advantages of mediation, which are that they'll reach a result that is their agreement, not an agreement that's foisted upon them by a judge. It's an agreement that they may not either one love, but they both can live with because it is their agreement, that they'll save time and money in the long run because they won't go through expensive litigation. And if there's children involved, oftentimes it's the best result for the children too, because there's no fighting that's going on, and so none of that gets passed on. Even though you're trying to keep it from your children, if you're good parents and not involve them in it, they can sense it and see it if disagreement and arguments are going on.
Sure. So could you give us some insight as to what the difference in cost is? In my research, I saw $100 to $1,000 an hour. That's a spread, David. So what is... how does that work?
And again, I'm not sure what the spread is that you're referring to, but... Mediators,
$100 an hour versus $1,000 an hour, and I guess certainly depends on the state that you're in and what the case is, et cetera.
And what's at stake and that type of thing. So oftentimes in mediation, a mediator may charge per session, and it's not necessarily hourly, although it could be hourly. $250 to $300 to $500 an hour for a mediator, which is split by both parties, is not uncommon in many areas. But again, you're going to get something resolved, and usually quicker than in court, and you'll save time and money doing it that way. Some mediators will charge, like I said, per session. So it might be $500 a session, and a session will go for as long as progress is being made. Some mediators in family court settings especially will charge sort of a flat fee. Might be $2,500. This is what we'll charge you to resolve this case, no matter how many sessions we have to go. And at the end of all of those family court type of mediations, you end up with a memorandum of understanding, which is your agreement, which you would then have to take to a lawyer to turn into a property settlement agreement.
I understand that in some states, Florida being one, they're almost insisting that mediation happens first just because the courts are so bogged down and they find that there is good reason to proceed using that method first, and then if it fails, it fails.
That's true of many states. Many states will require mediation or arbitration before a case can proceed through litigation. Even federal court, federal district court has ADR, alternative dispute resolution. In many cases, the judges make that a mandatory approach before you keep continuing on a path of litigation.
So is it true that all lawyers could be mediators, but not all mediators are lawyers?
I will tell you what is true. It's that all mediators are not lawyers necessarily. Right. In family court setting, I've seen social workers who have made good mediators, and many other professions, people who are adept at getting people to open up and speak. And for mediation to be successful, you have to have full disclosure of all the issues, and in family court, all the assets and liabilities. And you have to understand what you're entitled to and what you want and what you need, but what you can give up and how you can be reasonable. And I've had many times where it's all about communication. I remember one case where the husband wanted to see the children on Thursday, the wife wanted him to see the children on Tuesday. And it was back and forth. So I finally got them to talk about, well, why is Thursday important to you versus Tuesday? And he said, well, because on Tuesdays I have this commitment that I've always had and I have to do that. And the wife said, oh, I thought that commitment was on Wednesday. Well, here's my issue with Thursday, but Thursday I can make work, but maybe Wednesday's better for both of us. And sure, once they started talking and laid out with some honesty what the issues were and why one date might be better than another day and so forth and so on, they came to their own reasonable resolution. So it's the communication in that part. But social workers sometimes are really good about bringing out what those differences are, or people who have a profession of getting parties to communicate.
So in talking about lawyers and mediators, can a mediator, one who's sort of facilitating things, also at times be an arbitrator? Do they have to have a separate set of licenses, or what are the rules? Certifications. So, how does that go? Because they're judge and jury, so to speak.
So you're not going to be an arbitrator or a mediator in the same case.
Not in the same case, right.
But you can be both.
Yes.
I serve in both roles. I'm on the list for Superior Court, court annexed arbitrations. But I'm also a mediator who's gone through the training and sent in the certification to family court back when they did do that. I don't know if they still do. But you just need to have the appropriate training, and in some instances you need to be certified to be on the list with Superior Court. The presiding justice has to allow you to be on that list and put you on the list. So the answer is a person can be trained in both of those areas, and in many instances in Superior Court cases, there are folks out there that we will pick as a mediator or we'll pick them as an arbitrator, and they can be the same person, but not for the same case. Okay,
fair enough. So when you are thinking about, as a lawyer, preparing a case, there are certain stages that you go through. Obviously, you're meeting with a client. Yes, you're getting documents together. Could you go through the process of, say, mediation and explain a little bit how they are having some similarities, even though they're obviously not the same kind of ultimate?
The preparation is actually pretty much the same in many ways. For a mediation to be successful, you have to have the case prepared as if it were ready to go to trial. You're not trying the case in front of the mediator, but you need to be able to inform the mediator of all of the strengths of your case, So the other side is going to expose all the weaknesses. You need to know those as well. And prepare the case as if it were going to trial without the necessity of preparing witnesses, because there's no testimony in mediation. So you don't have to have the doctor prepared to testify, but you need to know what the doctor would say, so that part of the demonstration of your case that you give to the mediator in laying out your case, you're prepared to do it as if it were almost like an opening statement.
And is that true with arbitration as well, as you're going?
Arbitration is actually more of a trial, because you are presenting witnesses to the arbitrator and you are presenting evidence. So it's not as formal as if it were a trial. There's no opening statement to a jury and no voir dire or impanelment of a jury, but there are many aspects that are the same. The rules are a little bit more relaxed. You can put in the medical records without bringing the doctor in to certify the records or having them go through the process of what you would need to do in a trial in Superior Court in Rhode Island, for example, but it's very similar, so the preparation is very much the same.
But in truth, the mediation is more informal. Arbitration tends to be more formal. There's a difference, obviously, between binding and non-binding. Yeah. When someone is trying to make a decision about whether or not they're going to deal with arbitration, assuming they have that choice, if the employer hasn't foisted it upon them, or however that goes, do you have the opportunity to dispute that the arbitration's decision,
arbitration decision,
and take it to court, to full litigation?
You might be trying to say arbitrator's decision.
Arbitrator's decision.
But it is an arbitration decision, so
yes.
I'll go with you on that.
Okay.
So if it's a binding arbitration, there are rules about confirming the arbitrator's award in Superior Court if you wanted to or needed to go that route. But I will tell you that to overturn a decision is very difficult. And a mistake of law or fact isn't even grounds to overturn. Is not. It has to go beyond that to fraud or some other.
I was going to say such a bias of some sort that shouldn't have been there.
Something that is beyond just what you could even appeal from Superior Court to the Supreme Court on a decision such as the judge made a mistake of law. You could appeal that. A fact you can't appeal unless it's like so against the evidence that it's like clearly erroneous, but it's hard, very hard not to overturn a decision that's on a binding arbitration.
So is that part of what they call rules of engagement? What does that actually encompass? And I guess the other question I wanted to ask about that is, when you're involved with arbitration, do you have already set in your mind, when you hear a story, what the high or the low limits might be and how you're going to resolve this?
That's another form of arbitration. You have arbitration that's non-binding, then you have binding arbitration, and you can have binding high-low arbitration where the parties agree that no matter what the arbitrator does, if it's above a certain amount, that's all that's going to get paid, the high. Or if it's below the amount, that the usually insurance company will pay at least the low amount, and they'll pay anything in between. So when you set a binding high-low arbitration, you're saying to each side, this is the exposure to you on the high end, and this is the minimum that I'm going to get on the low end, and both sides can and will have to live with anything in between.
Okay. So when you're working with one side or the other at given moments, how do you help prepare your, I guess you call it client still, how do you prepare that person for what their positioning might be? You've listened to all of the facts. You have to help them cobble together what would be the best position statement to present. How do you do that? How do you coach someone through that? Okay.
So we're not talking now about how we pick a high and low, but rather how we prepare.
How you prepare.
Okay. Just like you prepare for trial, you sit down with your client and go through all of the facts of the case with them. You say it's an auto accident. You go through all the treatment with them, who they treated with, what was done at each treatment, how the treatment affected their physical condition, what their physical condition is, if it's a permanent condition, how does it affect their daily living, the activities of daily living, so to speak. And then you just help coach them through, just like you would for trial. This is what to expect. There's the arbitrator. This is how this arbitrator operates. The attorney on the other side, you probably have already met because they took your deposition. They're going to do the same thing probably at the arbitration. These are the questions I'm going to ask you, and you just coach them through just like you were preparing them for trial.
Do you also have an occasion where you try to help them identify what the opposing parties' motivating spots or personal interests or business interests might be, so that they can more effectively present what they need to present? Do you actually help with that as well?
Sure, of course. You want them to understand what the other side's going to say, what issues the other side's going to raise. I once had a fellow who was injured working out at a health club, and the machine he was working out with didn't have the safety latch that many have, and it wasn't anchored to the floor, and it slipped and fell and came down and actually broke his neck. And I was explaining to him that they are going to raise a defense assumption of the risk because it didn't have a safety lock on it, and so there was a risk that it could come down on you. And I explained to him what assumption of the risk meant, that you had to appreciate the danger or the risk to you, and that you went ahead and did the activity even knowing that there was a risk. So when he was asked the question and they started going down that route, he's a very smart man. He was actually the CEO of a very large business in New Jersey. He was in Rhode Island for a particular purpose, business. And he explained to them that he worked out all the time. He knew the company that made the machine that he was working out on. He knew that the company that made the machine was the highest end manufacturer of that workout type of machinery in the world. And even though he worked out with another type of machine they made that had a visible safety mechanism that you could use, he assumed this one must have had an internal one, because why would they make a machine that didn't have some kind of safety mechanism? So there was no assumption of the risk because he didn't appreciate that there was a risk to him. And so it's just explaining the law and working through with someone what to expect from the other side. That's part of client preparation.
And in tandem with that, is there also what has to happen to help negotiate what that final disposition is? Do you end up explaining or coaching people how to negotiate if they're discussing in mediation themselves? I'll give up this if you'll give up that. Do you coach each side on how to negotiate with the other?
So as an attorney, I'll explain to my client, these are the upsides and the downsides of your case, so that you understand how your case is valued. But on top of that, I'll explain, but a mediator, a good mediator, will also explain, these are the risks and benefits of settling versus going to trial. So as you're going through mediation, not only is the settlement going to be based on what you think the case is worth and what the strengths and weaknesses of your case are, but also what are the expenses of going to trial and what are the risks. So many times you'll look at a case and say, well, this is what I could get on a really good day, X. This is what I might get on a bad day, Y. Where is the settlement? Is it somewhere in between there? And what are the chances if I went to trial, 10%, 20%, 100%, 50%, that I could get more or less than where I'm at? And how much will it cost me to find that out? So those are some of the factors going into a superior court civil litigation arbitration that you might factor into trying to determine whether or not a case could settle or should settle.
Good. As you've been addressing the civil side of it, divorce cases and family issues, speak to, for a moment, if you will, the business side of it. If you're in a personal relationship, you have that personal heat, perhaps. Maybe you have that in a business situation, but perhaps a little bit less. Is mediation then sometimes easier, or not necessarily, because sometimes people can be very hot and tenacious about a certain point in business, just as they might about who's getting the family dog?
Yeah, I mean, you can have those same issues in business that you have in family court, but there's also the business expense and the business judgment and the business decision that might go into resolving a case. And mediation can be very good at getting two parties together to make the determination that a case should settle. And it's not always just the money. Sometimes there's business reputation, sometimes there's business delays, sometimes there's refinancing going on and you don't want this case still on your books before you go through that. There's a lot of other decisions that can go into settling a case that's a business dispute.
What about the relative time frame? We say it sometimes saves time. Arbitration could take months to get a case together. Is that true of mediation too, both on personal civil issues as well as business?
It can take time to get a case to the proper point where a mediation or arbitration will be successful. So you're talking in those terms months versus years usually, whereas years to get a case to trial, minimum 2-3 years, unless there's some element of a case that's emergent and subject to like a restraining order or some type of thing where it might come up to trial much quicker. But for most litigation, where it's about money or something of that nature, you're talking years to get to trial versus months to get to arbitration.
And then once it's presented, though, it doesn't take a long time to make the decision after that, does it?
Not
that could be relatively a week versus months and months and months.
Yes, it can be quick.
And when it comes to arbitration, when you have credit card companies and telephone companies, many of them won't even let you sign on or even become an employee without you agreeing to arbitration.
Yeah.
Speak to that.
Those contracts of adhesion, where they have their language, accept it, take it or leave it, kind of things. Sometimes it's to your benefit, sometimes it's not. I will argue to the end of time, and I probably win some and lose some, that those contracts that you sign that say you live in Rhode Island or Massachusetts and you have to go to Minnesota to arbitrate a case, I might argue there's a little overreaching and not an arm's length transaction in getting to that term of the contract.
So if you had a credit card, would you not take one because of that?
There's a lot of other factors that may go into that decision.
Too easy to get. How about when it comes to something like MGM quickly that's had such a terrible thing happen, a shooting? They were talking about litigating it, now they're talking about mediating it. Which is likely to, is it more likely when you have so many people involved that they're likely to settle that?
The mass tragedy type cases. Oftentimes, mediation or even some form of arbitration is a good way to bring all the parties together and start coming into some kind of resolution, as long as all the parties are being joined together in some form or fashion. Good
to know. Well, we hope that this has been helpful to you. We hope that you have some additional insights when it comes to such ADR. And please stay tuned to The Law Matters, because as we say, it matters to you.